All right, then. So this is our title page. We're going to talk today with Jim Waltz. This is going to be actually a pretty interesting conversation, I think. Well, I always say that, don't I, even when they're not. But this time, I think it will be. It's information that I always wanted to know when I was doing M&V. I used to work for JCI years ago. And this was something that always scared me. What happens when or if I end up getting called by lawyers and all of a sudden one of my projects is going wrong, the customer's unhappy and they've gone to their own legal counsel and now they want to put me on the hot seat. What's going to happen? Am I going to get in trouble? What do I do? What do I not do, et cetera? And I hope Jim's going to tell us all of that stuff. But first, we should tell you a little bit about Jim. So this is a little blurb about him. Oh, shoot. Still there? There it is. And Jim's been around for a while.
Blurb.
Go ahead. Yeah. So he started in the early 80s. He was involved in writing, or let's say forming, the performance contracting methods or procedures for one of the huge ESCOs back then. There was 3 really big ones. And so he helped put one of those together. And they're still around doing performance contracting. And also, he's written a couple books. Actually, I have them right here. I'm going to show them to you in a minute. And yeah, I used to teach a seminar on performance contracting. Hey, Tyler, can you make those slides go away and show us instead? All right. So this is the first book he wrote. This is it's old. I mean, gosh, how old is this? 1980s? No, early 1980s. I bet it's late 80s.
Something like that.
Yeah,
since it has nothing to do with software, it's timeless.
You know, so that's what I was going to say. So I mean, look, if you look at some of these pictures, they're like, oh, God, that's old stuff, you know. But the thing is, it's about modeling, and it's about the appropriate way to go about modeling in general. It doesn't teach you how to use Trace 600 or half or any of that stuff. Not at all. It just teaches the basics on, let's say, the context, but also the basics of modeling and what happens if you don't do a good model and how your ESCO project's going to go to crap. This book he wrote is on M&V, and actually I have a chapter in it. It's the first thing I ever wrote and published. And there's other writers too. Cromer's one of the writers, a guy named Marty Mozo, which some of you may have heard of. He was a writer. Who else do I have in here? Kevin Frazier.
There were a number of contributors, yes.
Yeah, and then Lou Roncesvalli. Anyway, again, if you like what Jim says or you like the way he talks and thinks, this might be a good book to look at. He's kind of, the thing about Jim that's different is he's a little sharper with his language than most people. And when I mean sharp, he'll say things other people don't say. I guess I do that too. I learned that from him. But he's much better with words than I am. Anyway, let's get going. Did you want to add anything more to your bio, or we can just get going? What do you think?
No, the bio is fine. The bio is fine. What I would like to do is make just a couple of opening remarks about things that I consider to be truisms, maybe only a couple, and then maybe go into a couple of my case studies that I think are illustrative or illustrative of some of the fundamental issues we're talking about. At a certain point, we do need to share with them the HPAC article that was recently published on forensic engineering, because it will give, it's nothing about doing the engineering, it's how you deal with lawyers and special masters and mediators and arbitrators and things like that. So it's about that experience, and I think there's some good insight in that. I certainly have been amazed at what I've learned doing some 30 years of expert testimony work, including a lot of performance contracts. So, and then what I would like to do is, do we usually entertain questions as we go along?
Absolutely.
Okay. Well, I am here in service to our attendees. Same way I taught at San Francisco State. I'm here to share my experience with you, hopefully there will be some value in that. We have double cross fingers for that, by the way.
You never know.
Here's one of the key points that Steve Cromer and I arrived at totally independently, and were shocked that somebody else had formed this conclusion. And here's the conclusion: savings cannot be measured. I'll say it again: savings cannot be measured. So there's this whole little mini industry called M&V, and it's like, well, of course we're going to measure savings. Well, you know what? Savings is the energy you're not using anymore. It doesn't exist thanks to your good efforts or somebody's good efforts. You can't measure it. You can measure the energy use before and the energy use after. And if all things are equal, the difference is, I'll call it savings when it comes to energy, and cost avoidance when it comes to dollars and cents. Remembering that if you reduce, let's say you reduce a building's electrical use by 10%, but let's say the PUC ups the rates by 10%, and guess what? Your bill is the same. If you're dealing with a casino owner and you've promised them cash savings as opposed to cost avoidance, you could be in real trouble.
Yeah.
They could haul you into the back room and have a serious conversation with you. So, and the other problem, and John deals with this all the time because he's a proponent, I would say, of option C, which is whole building measurement and verification. There are many potential confounding factors, and I'll cite one particular little case. A county in California, at the county headquarters building, beyond the control of the facilities management people, the two different departments did major changes to the building that they were in. In one case, they installed a nationwide fingerprint computer system in the basement, including servers and air conditioning and all this. The building engineers didn't even know it was happening until after the fact. Another department decided that the big atrium that went down through the middle of the old county courthouse was a perfect place to throw some beams across a couple of floors and build out new space in the building, new space. So the actual occupied square footage of the building, including HVAC, lighting, and all that, changed. And you went into the courtrooms that were next to that used to have a view out onto the atrium, and the windows were still there, but they were blanked off. And, you know, I think they put some lights behind the glass or whatever to make it look like they were windows to the outside. Another quick question or quick observation is that, you know, under the IPMVP or the MVP, whatever it's called these days, and I was on the committee in '97, and then kicked off afterwards because I said, well, you know, I don't care how much energy you're saving. The owners want to see money, and the MVP still does not address what the value is of units of energy saved. And there's a chapter in my book on that. So you can look at that. You know, we have 4 options, A, B, C, and D. They all suck. They all are flawed. It's like computer models. All computer models suck, but they may be very useful, and it all depends on how you use them. And I didn't have this in my notes, but you know, the ladies are always telling us it's all about the relationship, and I think we have a few ladies in our audience here. But the truth is, in performance contracting, it really is all about the relationship. You can, if you strike the appropriate relationship as an ESCO with your building owner, you can eliminate 95% of the potential problems. I worked on one very large project for NASA, and the project manager was for NASA was a very practical guy, and we made fairly sweeping changes in the scope of the work that we were implementing for them, and it was okay. It wasn't a problem. We sat down and said, okay, here's what's going on. You know, our original concept was flawed, you know, and you know, no project is perfect. And we said, here's what we'd like to do as an alternative. And we were able to accomplish that, and happily so on both sides of the table. Now, and here's my last truism. Mr. M&V, the guy that comes in at the tail end of this whole process, may be hopelessly compromised.
Yeah.
If you have a sales-driven ESCO organization and you're working for that organization, or you're their consultant, do they really want you to come in and tell them that, well, you know, we're not making any energy savings? No, they're not interested in that. So, and that is why some of these case studies are kind of important, because they sort of touch on, reveal the kind of relationships between the various parties. I used to use the term mutualization of motives, that the best performance contracts are when the ESCO and the owner share the same motives. And I also developed a concept I called being positively devious. And devious in the sense that your customer may not have any real ability to understand or deal with all the information that might be available. So if you are being positive in your relationship, you present them with the information that is maybe a subset of what's available, but it's information that they can deal with. And if you have the owner's best interest at heart, which is what you should be doing as an ESCO, that's not a problem. You should be able to do that. And but you have to, in your heart of hearts, have the customer's best interest in mind. And one of my case studies will reveal that very clearly. And with that, I think I'll dive into the case study that reveals that most clearly. We had a high-rise building in the Southwest, in one of the major cities in the United States. It was owned and operated by one of the largest property owners and managers in the country. And it was like a 1.3 million square foot facility. And we were actually hired to do the energy audit. Well, the sales engineer, at one point, we're driving to the job site, and he says, I think we've got a $4 million project here. And I said, I think we got about a $2 million project. And he didn't like that, but he didn't say much. Well, it turns out that once the official report of our energy audit, which included 6,000 electrical readings, we opened up every bus tap switch on the bus risers. We opened up every starter in the motor control centers. We directly measured more than 90% of the connected load in that building using an AEMC power factor meter, volts, amps, and power factor. And if you don't know what the term power factor means, you really shouldn't be in this business. So the report goes in, the sales engineer pulls out the section of the report that deals with building automation, because he really wanted to sell a lot of controls. And he substituted his own calculations based on an in-house energy saving calculation program. And all the big companies have these. and he hands it off to their corporate people, and they review it. And well, there was one little problem. For example, the building automation system was estimated to save $150,000 a year in natural gas due to refining the operation of the HVAC systems that mixed heating and cooling. Well, there's only one small problem with that. The baseline use established for many years was about $50,000 a year of natural gas use.
Wonderful.
This was a Fortune 500, and they guaranteed $150,000 a year in savings. And I was later, when the customer complained that they weren't getting the savings that they thought they should be getting, the branch manager of that Fortune 500 asked us to come into town to audit the project, not audit the building, audit the project. And when I presented my report at the end of my week, I said, you know, our services don't include expert testimony. And the branch manager said, I don't understand. What do you mean? I said, well, you know, once you hear what I have to report to you, you may want to take legal action against your former sales engineer, who was still working for that Fortune 500, because he scammed his own company. And the M&V guys at their corporate headquarters looked at the gas use, and there was a little problem. For 1 year, they had a different chief engineer running this high-rise building, 1.3 million square feet. It was in, again, the Southwest, not much of a winter. Okay, Oklahoma gets really cold, but if you go a little further south, it's not so cold. So anyway, the guy who was the M&V expert at their corporate headquarters says, well, you know, we have this 1 year of data that's an outlier, and our coefficient of what's it called, John? Coefficient of...
Oh, God. R squared value is what you're talking about.
R squared, yes, R squared. Because you do linear regression analysis or multivariable linear regression analysis, and you come up with a coefficient of correlation, I think is what it's called. Yeah. And rather than, and then the old engineer came back. Well, the new engineer ran the boilers in the building from like October through March. The old engineer put the boilers on for about 6 weeks, basically just before Christmas to just into February. And the difference was $100,000 in natural gas per year. And somehow or another, the boys at the corporate headquarters missed the fact that the long-term history of gas use was $50,000 a year, but they were guaranteeing $150,000 a year. I call that the plausibility check. Does it make any sense at all? Great. You know, you're going to ship energy back to the utility company. Or, as I saw one county job, the ESCO literally was acting like they were going to load up truckfuls of savings and deliver them to the buildings. And that didn't work out very well. So the bottom line was that the ESCO in this case, and we went back and redid the 6,000 electrical readings, by the way. And it turned out that not only were the gas savings off, but the sales engineer decided to replace our saving numbers for the lighting. He based it on something like 25,000 fluorescent fixtures that somebody thought had been installed in the building. Our direct measurement was right on. There were about 20,000 fixtures. And our numbers, when we went back and reevaluated, our savings on lighting was about 93% of what we projected, that's pretty doggone good. And but he had guaranteed a much bigger number. So ESCO had to write a check, a big check, and they lost their business relationship with this owner who was owned and operated a whole bunch of buildings all over the U.S. And again, I won't be naming any names today, but take me out for a bottle of Zinfandel and you might find out. So we will have to see. So they lost that account by screwing the pooch. That's a technical term on this major performance contract. I'll show you I'll talk about a slightly different case study. This was a university, a public university in the state of California. And the performance contractor got a job to replace a 3,000-ton chiller in their central plant. And there was a requirement in the contract to do M&V. Well, it wasn't really a performance contract, but there was an M&V requirement. So that kind of makes it like a performance contract because you're required by contract to demonstrate the results of the project to the owner. The only instrumentation that they had electronically was chiller amps, okay? But they had a nice new digital control panel on the chiller. It's one of the major chiller manufacturers in the world, in the US. And to show the part load, the M&V guy went in and he watched the chiller at different amounts of loading through observing readings from the chiller control panel that gave him volts, amps, and power factor. When he got done with his calculations, it wasn't right. The numbers weren't right. And by the way, one of the chapters in the book that John helped me write on measurement and verification and management of performance contracts, there's a chapter in there that talks about exactly this sort of thing. So the M&V boy for the group that I was working with was stumped. The project sat dead for a year with a $500,000 invoice sitting on the table on the owner's desk, not getting paid because we were unable to produce an acceptable M&V report.
Crazy.
$500,000 sitting there. If you or I had somebody owed us $500,000, we'd be knocking ourselves dead to try and get that solved.
Right.
So to the rescue, finally, one of the more higher ups said, well, I can't believe this has been sitting for a year. Why didn't we ask Jim to come in and take a look at this? So I went up to the university, and it was a central plant that had a 1 million-gallon chilled water storage tank associated with it. So we could load up a chiller anytime we wanted to charge the tank. So one night I went up there, we ran some tests on the chiller. We started at low load and worked it on up to high load. And I'm writing down numbers from the chiller control panel. Beautiful control panel. And what I'm realizing is, as the numbers change, the power factor isn't changing at all. Not hardly at all. Very little power factor change. And if you understand induction motors, at low load, they have a terrible power factor. So what we realized was this doesn't look right. And even the operating engineer that was standing there with me helping to do this test, he says, that can't be right. So we got on the phone about a week later with the manufacturer at their corporate headquarters, the chiller manufacturer, and said, we've been looking at the data we're getting out of your control panel, and it looks to us like your power factor numbers are baloney. And the product manager said, yeah, you're right. The power factor numbers are not reliable. And so what we ended up doing, and because I had a very good relationship with the director of engineering, director of facilities at that campus, he and I actually were both alumnus of the same design build contracting company in prior years. I said, well, let me tell you, we have a little problem. We really don't have the right instrumentation. What I'd like to do is write up a report that shows you that the full load kW per ton on this machine is as advertised because we measured it directly. And he said that would be fine. So I generated a report that showed all this information, presented it to the owner. The owner says, good, this is what I need in my records, and I will release the $500,000 invoice for payment. So I think what I'm trying to say here is that the M&V task can go both ways on you. It can take you straight to hell, or if you have a good relationship with the customer, it might not necessarily take you in that direction. And sometimes disclosure is very important, letting people know what the situation is and what can be done to make things right. Do we have any questions yet?
Well, I've got questions. I want to make sure we cover this because I think this is what's most important, at least it would be to me if I was someone in the audience, is when a project goes bad and the client no longer trusts the ESCO and they don't trust the M&V report or something, they think something's shady, and they go and they initiate legal proceedings or whatever, what happens then? How does that work?
Well, you can have a complaint or something and a claim, but it is not necessarily a lawsuit that's been filed. It's kind of like submitting an insurance claim. And that's the time where you have the opportunity to perhaps on your own informally kind of mediate the situation. If you really have, I'm looking at my case studies that I've got notes on here. If you really have a good project, you may be able to negotiate your way out of that. But I will tell you that once it goes to an actual lawsuit being filed, you're going to end up in front of either a special master, a mediator, or an arbitrator. And each of those venues are a bit different because most of what takes place in front of a special master is very informal, not under oath discussions and exchanges of information. The moment you get into, go ahead.
I don't understand. What's a special master? Is that means they're not mediating or arbitrating? Does that mean they're going the legal route, the court route?
Well, it's a non-judicial process. And John, this might be a good time to put up the video or the screenshot of the forensic engineering article. I'll talk about it a little bit, but this article, it's essentially in the public domain, although it's copyrighted. In my opinion, you're welcome to use. Whoops, there you go. Scan down a little bit.
Yeah, I will.
Scan down a little bit. I'm watching you, John.
Okay.
Right there, the title. Go back up and show the title again, just a little higher.
Article in HPAC engineering, but
right there.
But you
go
want
ahead.
to make sure you
right there.
Type in hpacengineering.com because you're going to end up with a really weird website. It's hpac.com. You could do a search for his last name, Waltz, or I guess the word forensic, and you'll find this.
Yeah. This doesn't talk about specifics of any particular project or calculations or anything like that. It's all about the legal process. So a special master is one non-judicial process that the two parties can agree to. They agree to having typically the special master is like a retired judge or a retired lawyer that wants to stay active And I think it's a good thing for them. Their principal goal is to resolve the case without it going to trial. Trials are very, very expensive. But at the same time, the special master's goal, if he believes that someone has been injured, his goal will be to see if he can find compensation for that injured party.
Right.
And by the way, if you're one of the usual suspects in the case and you don't have insurance, you will probably, insurance coverage, liability coverage, you'll probably be let out of the case because the special master is trying to find some money. And what I would say is that if you're a consultant to an ESCO and you have taken the option of not buying any errors and omissions insurance, 95 to 98% chance you'll just be let out of the case. Because I had one special master that said, I'm not going to go after the engineer's home and car and his retirement. I'm not going to do that. If you don't have insurance, leave the room. And I call that the nose count. If there's a $10 million claim and there's 10 defendants, it starts out everybody's in, quote unquote, in for $1 million. The special master will have a meeting with the defendants and say, who doesn't have insurance? 5 guys raise their hand. He tells them to leave. When the door shuts, he turns to the remaining 5 people and advises them they are now in, quotes, trying to do quotes there, air quotes. You're now in for $2 million, not $1 million, $2 million. In tort cases and civil cases, your culpability is based on whether you have coverage. It has nothing to do with whether you've done anything wrong. So if you're a private practitioner and you don't have E&O, you probably are not at particular risk. If you are a big ESCO, you're at big risk.
Well, unfortunately, ESCOs all require you to have E&O, otherwise they won't work with you. At least that's my experience. Right. But that aside, right. So there's arbitrations, there's special master, and what was the third one?
Mediation.
Mediation. But you do expert testimony, so that is when they aren't doing any of those and they actually go to court, right?
No, the experts will be involved, hopefully right from the beginning. Although what tends to happen more often is the defendants kind of fold their arms and wait to see how nasty the case gets before they bring in their experts. The plaintiff, before he can even file a lawsuit, has to have an opinion from an expert that yes, there is a valid claim here. Now, some experts, they're not supposed to be, but they get compromised. There's one very large university system that is well known for waiting until the statute of limitations is about to expire. They hire a bunch of experts and they sue everybody. They sue everybody. I was on one $25 million case where they first sued the contractors and got a settlement and blamed everything on the contractors. They got their settlement and then turned around and sued all the design professionals and blamed everything that they blamed on the contractors. They then blamed on the design professionals, even though they'd already gotten the settlement for all of these damages that they thought were real and they claimed.
Were they real damages? Were there real problems here, or is it just this is just their policy? Every time they build a building, they just turn around and sue everyone like 9.5 years later.
Well, here's the problem. They have sort of what I will call captive consultants who do expert work. Oh. And the captive consultants feel obligated to pony up a bunch of claims, whether they're real or not.
Got it.
I had a case of a swimming pool that was, the owner said, this was part of that $25 million deal. The owner said, well, the ventilation for our indoor pool is not proper because the supply diffusers are right next to the returns, and it's obvious that the air goes out of the supply and goes right into the return, and therefore the air down at the level of the pool surface, which is where the people are, is foul air. Now, they didn't close the pool because the air was unsafe.
Yeah.
Which tells you a lot. And they had their consultant come in and run a test where they introduced smoke into the air handler. And indeed, the smoke came out of the diffusers, and diffusers are supposed to spread the air out. That's what a diffuser is. And lo and behold, yes, some of that smoke was shooting over right at the return grills, actually. And they said, there it is. It's proof positive. And I conducted a different test where I put a little smoke bomb in a floaty with an anchor, had one of my associates put on a swimsuit. He went over in the middle of the pool, right below, there were like 3 or 4 sets of linear diffusers. He set the floaty right underneath one of the rows of diffusers and lit the smoke bomb. And then we had a video camera watching. Well, I'm going to step back here a little bit, and I get myself confused here. Diffusers make the air go out, and by doing that, they suck, come on, suck the air. They suck the air back up right to the face of the diffuser. In fact, Barbara Coleman used to have temperature controllers, room temperature controllers, where the sensor was mounted in the center of the face of the diffuser. I was like, no, that can't be right. Except one day I put my digital thermometer up there and said, is this correct or not? The exact temperature of the room was being measured by that temperature sensor sticking out of the bottom of the diffuser. So anyway, we set up our smoke bomb and our camera, our video camera, and we watched the smoke rise up, go up towards the diffuser, be entrained by the air coming out of the diffuser, circled around, and we eventually saw the smoke come down and touch the surface of the swimming pool. So here we had an expert, one of the best known consultants in a very large West Coast city, who was proposing that there was a problem, claimed to be able to demonstrate it, and they were totally full of baloney. And notice I used a nice word there. And among other things, they claimed there was a problem with an air intake for a generator room that came out of the little kitchen in this building that was the source of the subject of the $25 million claim. And they quoted a code, mechanical code chapter that said you can't have that intake that close to the exhaust. We asked the consultant from the other side, well, what code are you referring to? And he says, well, the mechanical code. Well, this was 10 years after the project had been built, and the chapter in the code that he was referencing did not exist until 5 years after the project was built. And I think we all know, should know, that the code that is in force is the one that's in force on the day you file your application for a building permit. So this consultant had no idea of what they were talking about.
Hey, Jim, I want to shift gears. We've got just 12 minutes left, and I really want to go over this.
Go for it.
If you're an M&V person and you're facing you have to testify in front of, I don't know, a lawyer. I mean, if you're doing arbitration or mediation, are there lawyers in the room or special master?
Well, for example, in arbitration, everything is done under oath. That's different than mediation and a special master. But if you are in deposition, and that goes on sometimes in mediation and having a special master handling the case, depositions are done under oath. And one of the subjects I talk about in that article that appeared in HPAC is the concept of the unanswerable question. And I refer to the movie My Cousin Vinny, where I keep looking at you, John, in my computer. So if my eyes seem to be wandering, it's not because I had too much to drink last night. Miss Mona Lisa Vito is proposed as an expert on automobiles. The prosecution says, I want to voir dire her because I don't believe that she's an expert. And he asks the question, what's the ignition timing on a 1955 327 Chevrolet engine? And she says, I can't answer that question. And the judge says, yes, you will. She says, but it's a trick question. He says, what do you mean a trick question? She says, well, they didn't put the 327 engine into Chevrolet sedans until 1964, not 55. So I actually coined the concept of, I'm going to give you a really simple example of an unanswerable question. What is the color of the letter 9? And the problem with that question is that it assumes facts that are not in evidence. And opposing counsel will intentionally or perhaps unintentionally ask unanswerable questions. And as an expert witness or somebody who is being deposed, not as an expert, maybe as a percipient witness, meaning you are a fact witness. Proper term is percipient, but we use the term fact witness. They will sometimes ask you the same question in 4 different fashions, hoping that you will fix the question for them, answer the question that you've morphed it to, not the one that was actually asked, and then impeach your testimony at trial. You know, Mr. Avina, were you lying under deposition or are you lying now? Because the record of your deposition testimony and what you just said are not the same. And that's a common trick. And if you're an expert going in, sometimes opposing counsel, like at trial, in particular at trial, you know, Mr. Avina, are you being paid for your testimony? Well, if you're an expert, you're getting paid, but you're getting paid for your time, not for your testimony. Your testimony cannot be purchased because you have an ethical obligation and a statutory obligation to be truthful. So I don't know whether I'm touching on that enough for you, John, or whether I should do another case study or whatever.
No, but if you, so if they ask you a question, like you said, one of these unanswerable questions, how do you answer that? Do you say, this question doesn't make any sense, therefore I can't answer it?
That, in essence, is correct. And what I will do, I actually had a lawyer years ago in the 9th hour of the first of 2 10-hour days of deposition, pounded the table and said, Mr. Waltz, you're not going to wear me down. And at that moment in time, I thought to myself, well, number one, I wasn't trying to wear you down, but you were trying to wear me down. And number two, if I had been trying to wear you down, you just let me know that I succeeded. So what I do is I try to listen very carefully. And engineers, this is in my article at HPAC, engineers are problem solvers. If somebody asks a stupid question, it's our nature to want to fix the question so it can be answered. That's a mistake in legal matters. Big mistake. You have to answer the question that's asked. So I will listen carefully. If the question doesn't make any sense to me, I will then kind of bow my head, ask the question to be asked again, trying to reduce distraction. If it still doesn't make any sense, I will actually lean back, fold my arms, close my eyes, and ask one more time, could you please repeat the question? And if it really is an unanswerable question or needs all kinds of explanation in order to answer it, I just say, you know, the question makes no sense whatsoever. To answer it would require a whole bunch of speculation on my part, and therefore I am not offering an answer. And there are times when counsel will actually, opposing counsel, will try to browbeat you and intimidate you and say that you're violating your oath because you held your hand up in deposition and said the truth, the whole truth, and nothing but the truth. And you have to be prepared for that. It's being in deposition is not easy.
Jim, have you ever heard of M&V people getting in big trouble, like going to jail or let's say being fired from after going through this legal stuff?
Well, I have not heard of anybody being charged with any kind of criminal activity. I have done one expert case that involved criminal activity, but it had to do with asbestos abatement and the falsification of the information related to that by the contractors doing the work, and a judge wiping his finger across his desk in the morning and finding dust on his desktop. Getting fired, that's another question. If you are working for a Fortune 500 or a very large ESCO, and let's say you did screw up the M&B, and there's a chapter in the book. I think one of our co-authors contributed it. You know, what do you do? I think Marty Mozo wrote that one. What do you do when the M&B is wrong? Your job may be in trouble. There was a lawsuit filed by a very large ESCO some years ago on a school district project, and a consultant was hired to come in and audit the project, and they came back and they reported what they found, and the owner said, "Holy cow!" And in particular, this particular ESCO told the customer they were going to restore their boilers, and in fact, the consultant went in and said, if you go in and have a car restored, you expect it to pretty much look like new. And quite honestly, most public agencies, they aren't so much interested in the savings. They're interested in getting infrastructure renewed and restored and repaired. So anyway, the consultant went in and he looked at the boilers, and he could not see any signs of any work being done on the boiler. And the performance contractor, the ESCO, later claimed, well, we didn't actually promise to fix anything. We just promised to reduce your energy use. And of course, the customer was like, no, I'm not buying that. You said restore. And the smoking gun in that particular case, and again, no names mentioned, was an internal email on the ESCO side of the table that said, guys, we need to sell our way out of restore, because there was another very large, multi-tens of millions of dollars of follow-on work that the ESCO was hoping to get. And the owner just said, that's it, we're done with you guys. And,
we're almost done with time, but I just want to make sure before we got 3 minutes left. So I want to get this in. So I would think this is, if you're doing M&B and you're really frightened, let's say that this thing is going to go to court, and the M&B is bad, and that's your responsibility. Let's say you were the M&B guy. Would you?
Okay, the M&B per se isn't bad, but it doesn't show the results that were promised to the customer.
No. Sometimes in ESCOs, maybe few times, but every once in a while, there are forces that somehow end up happening where you end up with an M&B report that's really not very accurate. Now, does that happen a lot? Probably not. But let's say you have a mess. Maybe you inherited a mess. Maybe you got hired, you're brand new, and there's this mess, and you're supposed to deliver this report, and you don't believe any of it. And it's overstating savings and all of this. What would you do? I mean, I would think what I would do is I'd probably quit rather than have to be put in front of some lawyer trying to defend something I don't believe in. What would you do?
Well, I actually had a case much like that. It never got to the point of a lawsuit, but there was a county project done by a design build contractor who did a HAP model of the building and promised a certain amount of savings. When they went to get their rebate from the local utility, the utility reviewer said, these numbers are off base. They're out in left field. Curiously enough, the contractor recommended that I be brought in to review the whole thing, and they were happy to have me do that. Well, the HAP model was crapola, and I reran the model, and the project was a good project, and they did the right things, but the estimate of savings was really bad, and I reran the model and trued up all the numbers like fan connected loads and things like that. You know, they had modeled the building such that all the fans were like 3 times the power that they were actually consuming. So the VFDs didn't save that much. But net, the project produced about half of the savings that the design build contractor had told the owner they were going to receive. The project was still a good investment. And the owner liked the contractor enough. Again, this is relationship stuff. They did good work. It was effective work. And the owner said, well, golly, okay, my rebate's going to be a little smaller, but I still got like, I don't know, a 12%, 14% return on investment. Instead of a 3-year payback, it was like a 7. And I'm okay with that. And so it doesn't always turn to crap.
Hey, thanks everyone for attending. Tyler, is there anything else?
No, you guys did a great job. Thanks for coming, everybody.
All right, thanks everybody.